Hello everyone, this is the part 2 compilation video of the RPC videos we've made so far. For your convenience, each rule will be chapterized. Are you ready? Let's get into it.
Rule 14. Dedication and devotion to the cause of the client. So Rule 14 is pretty straightforward. As a lawyer, you have to dedicate and devote all your time, effort, energy and attention to your client's matter. You have to do all it takes to serve the client's best interest, as long as what you're doing is not illegal. Sub-Rule 2 gives some examples of how you can devote yourself to a client's cause. One way is to always ask questions and double-check with your clients if you have doubts about the next step to take, especially when it's not within your professional discretion. For example, agreeing to an out-of-court settlement. That should be the client's call to make, not yours. You only suggest it to the client. If it's something within your professional discretion, however, like filing an application for an extension of time to file late processes, then you can take such actions without the client's input. Another way to do it is to involve your client in the process. Inform him of the progress of the case. If any important development comes up, let the client know. Also, if this type of case has a particular risk that's likely to occur, inform the client about it. If your client wants a situation report on how the case is going, respond to him quickly. If you see that the client's case is a hopeless one, then let the client know about it. No need to string him along because of the lawyer's fee you want him to pay you. That's unethical and it's not in the client's best interest. Usually in business, the customer is always right, but not in this case. Sub-Rule 3 allows you as a lawyer to exercise your independent professional discretion to take some decisions not to exercise the right of your client, as long as it will be in his best interest. Another highlight of this rule is that when it comes to court proceedings, if a client has engaged your services, you must be personally present in court. But if for some reason you can't be personally present, then you should get another lawyer to represent you temporarily. This is what is known as holding brief. Finally, if you are negligent when handling your client's affairs, that would amount to professional misconduct, which would attract serious disciplinary action by the Legal Practitioners Disciplinary Committee. Rule 15. Representing clients within the bounds of the law. Now, you know how the previous rule was telling you to be fully devoted to your client? This rule serves as a check and balance to that. Your duty to uphold the law always supersedes the duty to satisfy your client. If the client gives an instruction that would be unlawful, ignore it. But if he insists, withdraw your services. If the instruction involves actions like bribing judicial officers or witnesses, warn your client against such actions. If he insists, terminate your services. Don't give advice to your clients that it's possible to bribe a judge. That's disrespectful to the judge. Also, don't advise the client to disobey any law. Another thing you shouldn't do as a lawyer is to knowingly handle a case where the main purpose of it is to merely harass or intimidate the opposing party. That's an abuse of court process. If you know a claim or defense is unwarranted under existing law, don't waste the court's time by filing such a case. But if in good faith you believe such a case can be backed up by a solid argument, and no judicial interpretation has been given to it yet, then go for it. Rule 15 sub-rule 3D states that you have to inform your clients of the options of ADR, that's alternative dispute resolutions, before considering litigation. If he then insists on litigation, then go for it. Also, as a lawyer, you can't conceal or knowingly fail to disclose what the law requires you to reveal. For example, if you suspect that your client is involved in money laundering, Section 7 of the Money Laundering Prevention and Prohibition Act 2022 requires you to disclose it to the proper authorities. Don't conceal such an information. When you are in court, don't knowingly use perjured or false evidence. That's a crime. In the criminal code, perjury is a crime. In the penal code, giving false evidence is a crime. Another thing you shouldn't do is that you should not make false statements of law or fact in court. That's deception. Also, don't fabricate evidence to help your client's case. If you know an action is illegal, refrain from advising or assisting your client in doing it. Sub-rule 4 of this rule says that during the period you are representing your client, if you receive an information that he has committed fraud against another person, court, or tribunal, call on him to rectify it. If he refuses or neglects to rectify the fraud, then you have to report to the affected person, court, or tribunal. But if that information is privileged information disclosed to you by your client, you can't reveal it to the affected person. That would breach Rule 19. However, if the person who committed the fraud is not your client, then you have to reveal the fraud to the affected person. But before you reveal, make sure the client consents to it. Don't just reveal on your own. Finally, Sub-Rule 5 says that as a lawyer, You are not allowed to vouch for the integrity of your client or his witnesses to back up your arguments. The court works with evidence, so if you want to vouch for the integrity of your client, let the evidence you bring speak for themselves. And that's all for Rule 15. Rule 16. Representing clients competently. Last time, we talked about representing your client within the bounds of the law. Now we're going to talk about representing your client competently. Right off the bat, this rule states that if the case that your client has brought to you is something that you are not competent to handle, then don't handle it unless you associate with a lawyer competent in that field. So for example, if you are competent in corporate law practice, but your client brings a matrimonial causes case to you, which is not your field of expertise, you should either collaborate with a lawyer competent in that field or decline the case outrightly. If you let your client know and he insists that you do it, then you have no choice but to try. Another highlight of Rule 16 is that as a lawyer, you must prepare adequately before handling a legal matter. Take your client's interview seriously, listen, ask questions, gather facts and evidence, do proper research, and then create a trial plan. Basically, organize yourself properly. Also, it goes without saying that you can't neglect a legal matter that your client has brought to you. That shows professional incompetence. Lastly, if you've personally committed a professional misconduct or malpractice, own it. Don't try to exonerate yourself and throw your client under the bus. If you do that constantly, it's a surefire way to never get new clients. Referrals are very important in this profession. And that's all for Rule 16. Rule 17. Conflict of interest. In the last video, we talked about representing your clients competently. Now it's time to talk about Rule 17, conflict of interest. Now let's be real, we're lawyers, not slaves loyal to only one slave master. At some point, we'll have a lot of clients, and it's not outside the realm of impossibility that these clients may clash, hence a conflict of interest. So what does the RPC say? If you are representing a client who has retained your services for a particular matter, and the opposing party is also a client you've worked with before on the same matter, you have to tell your new client about this. By doing so, you are giving your client a choice to either retain your services or choose another lawyer for this particular case. This is more ethical than keeping quiet about it, because the opposing party can use it as an advantage against your new client. It's also possible that the matter can involve your own financial, proprietal, or personal interest, which in turn can affect your professional judgment. An example of it affecting your personal interests is if the case affects your family member negatively. If by chance the matter happens to affect those interests, don't accept a retainer unless the client consents to you representing him. It's important to note that this applies where the lawyer has a special retainer with the client on a particular case, not a general retainer for ongoing legal services for a specified amount of time. So for example, if clients A and B have a contract and there's an issue, you can't represent both of them on a particular matter because there will be a conflict of interest. However, if you represented client A in a matter, and then you are also representing client B, but not on that same matter or something related to that matter, but just on a general retainer, even if you've worked for both parties, there is no conflict in this case. Another highlight is that you can't acquire property which is a subject matter of a case you are conducting for your clients because that will conflict with your client's interests. The exceptions are when you want to acquire a lien to recover your legal fees and expenses, or when you contract with your client for a reasonable contingency fee in a civil case. Another highlight of this rule is that you can't represent two clients in the same matter at the same time unless you've discussed with both parties and they both consent to such representation. It's very possible to see this kind of thing happen in a contract of sale of land. An example is when a solicitor makes a sale of land agreement for both the vendor and purchaser, and both of them rely on his legal advice. Also, if you're a party to a case and your client is the opposing party, you can't appear as your client's lawyer. Finally, when a lawyer declines employment or withdraws from the client's case because of this conflict, a partner, associate, or any lawyer connected with you or your firm can't accept or continue that particular case. And with that, we've come to the end of Rule 17. Rule 18. Agreements with clients. In the last video, we talked about conflict of interest. Now we're going to talk about Rule 18, agreements with clients. First off, this rule gives the client the permission to hire or fire a legal practitioner as they wish. Basically, what this is saying is that a lawyer is not indispensable. If a client is uncomfortable with his lawyer's services, he can fire the lawyer and hire a new one. Nothing is stopping him. The only thing to consider is that if the lawyer has done some work for you, then the lawyer should be compensated for the work he did for you, even though he didn't get to finish. This is what is known as quantum merit. Also, when you hire a lawyer, as a client, you are obliged to perform any other obligation, both express or implied, that you owe to your legal practitioner. So in essence, just as the legal practitioner is devoted to the client's cause or matter, the client should also make sure that he does his part. Now, according to Sub-Rule 2, as a lawyer, you have to ensure that important agreements between you and your client are, as far as possible, reduced into writing. This would help you prevent stories later on from your client like, I didn't say this, we didn't agree on this, they didn't quote me. However, just because you fail to have the agreement in writing does not absolve you, the lawyer, from performing these obligations owed to your clients in respect of a particular brief. So in essence, if you fairly made a contract with your client, but you didn't put it in writing, it doesn't free you from performing that contract. And that's all for Rule 18.
Rule 19. Privilege and confidence of a client.
Let's talk about the privilege and confidence of your client. In this profession, lawyers need full disclosure of relevant facts from their clients to handle cases properly. This covers loopholes and prevents unexpected surprises that can be detrimental to the case. During this full disclosure, the client usually shares sensitive information, either orally or in written form. This information is considered privileged communication that you cannot generally disclose to anyone, not even the court. You also can't use such information against your client or to your own advantage, like blackmail for example. Now, there are instances where the lawyer may reveal such information. One of such instances is when you tell the client that you want to reveal privileged information and the client consents to it fully. Another is when the RPC allows it, for example, Chapter 2 of the RPC. Also, when the court gives an order, you may reveal if it's appropriate to do so. Another instance is when you are required by law to disclose it. For example, the Money Laundering Act requires a lawyer, who in this case is a designated non-financial institution, to disclose information through a report. Another instance is when you need to disclose the information to collect your legal fees. Also, when the client is accusing you of professional misconduct and in order to defend yourself properly, you have to disclose the information. Another instance where you can reveal is if the information will prevent a crime from being committed. This duty to not disclose also extends to your employees, associates, and anyone working for you that comes across such an information. The exceptions where a lawyer can reveal will apply to employees as well, but only if the lawyer is revealing the privileged communication through them. In court, don't talk or give any advice to the opposing party, even if he asks for it. Deal with the opposing party's lawyer instead. If that opposing lawyer does not have legal representation, don't communicate or mislead him. The court would usually provide legal aid if he's an indigent person. Final note on privileged communication. It's important to know that this disclosure must have happened during the course of professional employment. Any disclosure that happens before then won't be considered as privileged information. Also, that privileged information remains privileged even after the professional employment.
Rule 20. Lawyer as a witness for a client.
This next rule is talking about a lawyer as witness for his client. As a lawyer, if you reasonably ought to know that you will need to be a witness in a case you want to handle, or a lawyer working in your law firm will testify in that case, then don't handle the matter. Of course, with the RPC, you are not here for the general rule, you're here for the exceptions. The exceptions where the RPC permits a lawyer to be a witness for his clients are as follows. If the testimony will relate to an unconnected matter only, or if it will relate to formalities which the other party won't oppose, or when it relates to the nature and value of the legal services rendered to the client in the case, or if refusing to testify will injure the client's case substantially. Note, you can be a witness for another party, even the opposition, as long as it's not prejudicial to your client's case. Now, if you've already started the case, withdraw your services. You can give the matter to another lawyer who is not in your law firm, but where it's not possible to transfer the case to another firm, then you may give the testimony. But the catch is that you can't argue the credibility of your own testimony in the final address. Basically, you can't do this. In conclusion, a lawyer cannot be a witness on behalf of his client on the merits or substance of the case. If it's simply formalities or procedural stuff, or an unconnected matter, or relating only to the legal services rendered, then that's okay. He can testify on behalf of his client. When you are giving a testimony as a lawyer, you cannot be robbed, and you cannot remain in the bar afterwards. Giving substantial evidence also extends to affidavits as well. You shouldn't be the deponent on behalf of your clients. And that's all for Rule 20.
Rule 21. Withdrawal from employment.
This next rule is talking about withdrawal from employment. The general rule is that you can't abandon your client's case unless it's for a good cause. Some examples of a good cause are conflict of interest between a lawyer and his client, or when the client is insisting that the lawyer does an unjust or immoral act when it comes to the case, or when the client wants you to give a frivolous defense and he still continues to pressure you, even after warning him. Another example is when the client deliberately refuses to pay his lawyer's professional fees. Another instance is when the lawyer is to give testimony on behalf of his client as to the merits of the case. Another example of a good reason is when the lawyer is joined as a party in the same case he's handling for his client. Now, before you withdraw your services as a lawyer, you have to give the client reasonable notice to allow him engage another lawyer. It's important to note that this withdrawal bars not just you, but also lawyers in your law firm and associate lawyers as well from taking up the case in the future. In practice, a lawyer who withdrew his matter can only reappear in the matter on behalf of the same client with leave of court, and you do that by filing and moving a motion. After withdrawing from the matter, the lawyer should return part of the legal fees he hasn't earned and only keep the part he has worked for. If it's a contingent arrangement in a civil case, then the lawyer gets nothing, as he withdrew before the case was finished. And that is all for Rule 21. Rule 22. Calling at client's house or place of business. The general rule is that you should not go to your client's house or place of business to receive instructions. The client has to come to your law firm or a convenience place other than the office. If you are using your house as a law firm, you should come there. If you are outside jurisdiction, you can choose a neutral place convenient for both parties, like a quiet lounge. There are exceptional circumstances where you are allowed to go to the client's house or place of business though. These exceptional reasons are not stated in the RPC. That's because there are many situations which may justify you as a lawyer visiting your client in his house or place of business. For example, if the president wants legal advice from you on matters touching on state security, it may not be wise to discuss that in the law firm. The presidential villa is more secure. Another example is if the client is in detention, you can go and see him there to get your instructions. If the client is severely ill or hospitalized, you can go to him to get your instructions. If the client is very old and can't move, you can go to him to get instructions. If the client is a doctor who is scheduled to perform a serious surgery, it will be more convenient for the lawyer to come to the hospital to take his instructions. As long as the circumstances and reasons for your client not being able to come to the law office are justifiable, then you are good to go. Rule 23. Dealing with client's property. This next rule talks about dealing with your client's property. Now, as we said in Rule 19, your clients will give you privileged information in confidence. This is because of the special relationship that exists between a lawyer and his client. This relationship will involve you dealing with your client's property as well. Now, you can't exploit that trust the client places on you to your own advantage or personal gain. You can't take the client's property as yours. You have to keep the client's money in a separate account. Don't put it in your personal account. Make sure to account for every dime of your client's money. Keeping a separate record for your client's money shows accountability and builds trust. Failure to deal with your client's property properly is a serious professional misconduct and has serious consequences. And that's all for Rule 23, guys. Rule 24. Responsibility for litigation. Let's talk about Rule 24. Responsibility for litigation. The general rule is that as long as the client is willing to pay for your services, you have the responsibility to accept briefs brought to you. This is what is known as the cab rank rule. It exists to ensure that everyone has access to legal representation, regardless of status or unpopularity in the society. You can't pick and choose briefs based on your personal feelings. So if you are going to refuse a brief, it must be for a very good reason. For example, if it's against the lawyer's religious beliefs, then he may refuse the brief. A lawyer who's a Jehovah's Witness can't accept a brief to defend a hospital that did a blood transfusion on a Jehovah's Witness without his consent. It's important to note that the cab rank rule has to do with advocacy work, not solicitor work like drafting contracts. Another highlight of this rule is that the lawyer is responsible for the type of cases he brings to court or the cases he defends in court on behalf of his client. They can't be frivolous cases. You can't use the excuse of following the client's instructions to bring questionable cases to court. If the client wants you to bring a case that goes against your honor, you are not bound to do it simply because your client said you should do it. Also, a lawyer can't take decisions on his own when it comes to the merits of the matter. He has to consult with his client first. He can only take unilateral decisions on incidental matters that don't touch on the merits of the case. For example, fixing a date for trial or applying for adjournment. Now, it is most likely that the opposing party would want a convenient date for adjournment or a convenient date for trial. As a lawyer, you don't need to get the consent of your clients first before granting the opposing party such accommodation.
And that is it for Rule 24 of the RPC.
Rule 25. Investigation of facts and production of witnesses, etc.
Let's talk about Rule 25. As a lawyer, you are allowed to approach and interview the witness of an opposing party. You don't need permission from the opposing lawyer to do this. The opposing party doesn't own the witness. He just called the witness to testify, so there's no reason to ask permission from the opposing party to meet with the witness. Of course, this is subject to the RPC itself. If it will offend the RPC, then it won't be possible. For example, if the witness you want to talk to is the opposing party himself, then you can't talk to him, as that will offend Rule 19. Another thing you can't do with the witness of the opposing party when you meet him is to try to secrete him. To secrete a witness means to hide him so he doesn't testify, paying him off so he doesn't show up to the hearing. This is basically witness tampering, which is highly unethical, so don't do it. When it comes to getting a person to be your witness, the testimony shouldn't be for a price. It should be given freely and willingly. Of course, as a lawyer, you'd pay for reasonable expenses incurred by the witness, like transport fare. When advertising for a witness, the lawyer should ensure that the witnesses are not narrating a rehearsed version of events, but rather facts that they actually witnessed. When it comes to the actual proceedings, it is unprofessional for a lawyer to use unfair and abusive language against the witness of the opposing party. The lawyer also can't ask questions solely meant to insult or degrade the witness. This also applies to a witness that becomes a hostile witness. Finally, don't let your client's demands influence your actions when you are gathering evidence. And that is all for part 2 of the RPC compilation videos. Stay tuned for part 3, which focuses on your relation with other lawyers. As always, we are very grateful for you sticking around. Please like, subscribe, and share with your friends. And we will see you next time.